1909. A courtroom in Washington. A giant railroad company stands accused of a federal crime. But here's the strange part. A company can't sit in a jail cell. So who goes to prison when the criminal has no body, no face, and no hands? That question would change American law forever. Have you ever wondered what actually happens when a corporation, not a person, breaks the law? Stick with me because this story never really ended. It starts with railroads, secret deals, and a company called New York Central. It ends over a century later with something called a DAO. Same question, completely different century. Can you punish something that isn't a person? Let's go back to where this all began. By the early 1900s, American railroads controlled the arteries of the entire economy. If you shipped goods, the railroads set the price and the rules. Congress worried something dangerous was happening. Big shippers were getting secret discounts. Small farmers and factories paid full price for the exact same service. In 1903, Congress passed the Elkins Act, making it a federal crime for railroads to offer secret rebates to favored customers. New York Central and Hudson River Railroad Company allegedly ignored that law completely. Its freight traffic manager cut secret deals with the American Sugar Refining Company. Sugar shipments moved at a fraction of the published rate. Everyone else paid full price. It was quiet, it was efficient, and it was illegal. Federal prosecutors indicted both the traffic manager and the railroad company itself. 2 defendants. 1 human, 1, legally speaking, nothing at all. Here's the problem prosecutors ran into immediately. American law had never really decided whether a company could commit a crime. For centuries, English common law held that corporations had, quote, no soul to damn, no body to kick. So how do you punish them? You can sue a company for money. Everyone agreed on that. But criminal guilt? Intent? Those seemed like distinctly human things. The railroad's lawyers argued exactly that. A corporation cannot form criminal intent, cannot go to jail, and therefore cannot be guilty of a crime. If that argument won, the entire Elkins Act would collapse. Companies could hide behind their own corporate paperwork forever. The case climbed all the way to the Supreme Court. Justices heard arguments for 3 straight days in December 1908. Everyone in that courtroom understood what was actually at stake. Not just one sugar deal, the future of corporate accountability itself. Would the law treat a corporation as untouchable? Or would it find a way to reach through the paperwork to something real? On February 23, 1909, the Supreme Court finally answered. And the answer surprised almost everyone. Justice William Day wrote the opinion for the court. His reasoning was almost shockingly practical for its time. He pointed out that most interstate commerce was already run by corporations, not individuals. Ignoring that reality would make federal law meaningless. The court ruled that a corporation could be held criminally responsible for the acts of its agents, done within the scope of their authority. In plain English, if an employee commits a crime while doing their job for the company itself can be found guilty. You don't need a signed, sealed authorization for illegal rebates. The company benefits from the act, so the company owns the consequence. This idea had a name later. Respondeat superior for crimes. Let the master answer for the servant's actions. New York Central and Hudson River Railroad Company was convicted. So was its traffic manager. The corporation paid the price alongside the man. For the first time, American law had truly answered the question. Yes, a company can be a criminal, through the people who run it. It's worth sitting with that for a second. A legal fiction, a piece of paper, was just declared capable of committing crimes. This single 1909 case became the bedrock for corporate criminal liability in the United States. For the next 100+ years, every corporate fraud case, every safety violation prosecution, every corporate criminal indictment since traces its logic back to this railroad. But notice what the ruling actually required. A human agent, acting within their job, whose intent could be traced and proven. The law needed someone to point to. A traffic manager, a name, a decision made by an identifiable human being. For over a century, that requirement quietly held the entire system together. No human agent, no crime, no company guilt. Now let's jump forward, because in 2026, a very different kind of company started showing up, one with no traffic manager at all. On June 26, 2026, Argentina's government sent a massive corporate law reform bill to the Senate. It had taken more than 2 years to draft. involving the Ministry of Justice, deregulation officials, and legal specialists from across the country. The country's general companies law, the rulebook for how businesses are formed and run, hadn't been fundamentally rewritten in over 50 years. Alejandro Ramirez, Argentina's Inspector General of Justice, stood up and said the quiet part out loud. He said the existing law was, quote, built for an industrial economy that existed before the internet, before the knowledge economy, before AI. In his words, there was now a real gap between corporate law on paper and how business actually gets done in practice. Think about that. The rulebook for companies hadn't changed since before the internet existed, and business had changed completely. So what does the new law actually do? It leans hard into one theme: digitization. From the moment a company is born, under the reform, companies could be formed entirely online. No paper, no in-person notary visits, start to finish. Every company would get a public digital file, a single online record of its structure, ownership, and history. Argentina would also create something new: a national registry of companies, centralizing records that used to be scattered across regional offices. Corporate books and accounting records would move fully digital too, replacing paper ledgers that companies had used for generations. The reform also modernized older company types, giving small LLCs and closed corporations more flexibility in how they actually operate. One existing structure, the simplified stock corporation, would get folded into a single unified general framework going forward. All of this sounds like housekeeping, until you get to the one addition that quietly changes everything. Buried inside the reform was recognition for something almost nobody expected in corporate law: the DAO. DAO stands for Decentralized Autonomous Organization, a company-like entity that runs on code and blockchain voting instead of a boardroom. There's no CEO, there's no traffic manager cutting secret deals over the phone. There's a smart contract and token holders who vote. Rules are written directly into software. When conditions are met, the code executes automatically. No human has to approve each action. Ramirez framed this reform as necessary just to keep up. Quote, the alternative of doing nothing has a real cost for Argentina's economy. He argued that if a country wants to compete globally, it doesn't really have the option of leaving these questions unanswered. Fair enough. But recognizing DAOs as legal entities quietly reopens a question the Supreme Court thought it settled back in 1909. If a DAO breaks the law, spreads fraud, launders money, violates sanctions, who exactly do prosecutors indict? There's no traffic manager to name, no single employee whose intent you can point to and prove in court. The whole 1909 ruling depended on finding a human agent acting for the company. A DIO might not have one. Token holders are often anonymous, scattered across dozens of countries with no single person controlling the organization's actions. The code itself makes the decisions, following rules that were written once and then left running without supervision. So the reform's authors insist something important: they are not touching civil or criminal liability rules underneath all this. In other words, the digital tools are new, but they promise the accountability framework stays exactly the same. That's a reassuring line, but it leaves the hardest question completely unanswered. Accountable to whom? Exactly when there's no traffic manager? This isn't just an Argentine puzzle. Regulators worldwide are quietly wrestling with the exact same problem right now. In 2016, a DAO literally named the DAO was hacked, and roughly $60 million in cryptocurrency was drained out. There was no CEO to arrest, no board to subpoena, no traffic manager cutting a deal anyone could point to. The code had simply done exactly what it was written to do, even though nobody intended that outcome. Some jurisdictions have started treating DAO participants themselves as personally liable, precisely because the organization has no clear legal shield. Others are experimenting with new legal wrappers, treating a DAO more like a partnership than a traditional corporation. Meanwhile, AI systems are starting to make business decisions with less and less direct human approval at each step. An algorithm sets prices. An automated system approves loans. A trading bot executes thousands of trades without anyone watching in real time. If one of those systems causes harm, courts are back to asking the exact 1909 question: whose intent was this, really? The traffic manager hasn't disappeared, he's just gotten harder to find. Sometimes buried inside code nobody fully audits anymore. You have to wonder, did the justices in 1909 accidentally build a rule that depends entirely on humans staying in the loop? Because the moment humans step back from the decision, the whole century-old framework starts looking a little bit shaky. So here's where we land. In 1909, the Supreme Court decided a company could be guilty as long as a human was behind it. In 2026, Argentina is writing a law that welcomes organizations built specifically to remove that human from the loop. Same question, new costume. Can you hold something accountable when there's no one clearly steering it anymore? Maybe the answer is that we simply update the definition of agent again, the way courts have quietly done before. Or maybe we're heading towards situations where genuinely no one is legally responsible. And that should worry all of us. Argentina's reform bill is still moving through the Senate. How it ultimately treats DAO liability is still being decided. What's certain is that the railroad case from 1909 is suddenly relevant again, in a courtroom fight nobody saw coming. Because every generation, it turns out, has to answer the same uncomfortable question in its own new language. Who's really responsible when the one who broke the rules was never quite a person to begin with? That's the thread connecting a sugar rebate scandal in 1900s New York to a blockchain vote in 2026 Argentina. And it's a question we'll probably still be asking long after DAOs feel as ordinary as railroads once did. That's a wrap for today. Thanks for sticking with this one all the way through. I'll see you in the next story.